You are listening to Radio VR, where we look under America's armor at the social, economic, and political factors that help shape our culture. In order to do so, we are bringing in, as always, USC Professor of Law, Jody Armour. Jody, welcome back.
Great to be back with you, Andrew.
Okay, let's get right to it and start with the issue of the day. The Supreme Court just issued a 5-4 decision in the case of Sibelius versus Hobby Lobby stores that wrestles with the question of whether a company that doesn't believe in certain medical services on the basis of moral and religious standing can be forced to pay for it, or just be a part of the American Care Act. In this case, the really revolves around female contraception. The ruling was 5-4 in favor of the furniture maker and against the U.S. government. Is this a huge decision, or is this potentially a death by a thousand cuts, or is it a day of triumph for people of deep religious convictions?
Yeah, it's an important decision, and let's go through all those factors and take our time, Andrew. You're right. Let's get the procedural and legal disposition of it clear first. What the plaintiffs were saying, what Hobby Lobby and the other employer was saying, Conestoga, which is a Mennonite-owned, closely held corporation that builds furniture. Hobby Lobby, of course, is a kind of evangelical Baptist organization in Oklahoma, different parts of the country. But what they were arguing was that under the Religion Freedom Restoration Act, the Religious Freedom Restoration Act that was enacted in 1993, that under that act, we have a right not to support contraceptive coverage that violates our fundamental religious beliefs. Number one, do they fall under the statute? Are there persons? Because the statute only covers persons. It says that persons cannot be substantially burdened in their religious beliefs unless there are compelling and narrowly tailored reasons for doing so. So first question was, as Conestoga is a for-profit business, a person under this statute? And we've been down this road before, haven't we, Andrew? Think back to Citizens United, in which the court said, hey, you know what? Corporations are persons for free speech, for First Amendment free speech purposes. Now we're asking, are they persons for purposes of
freedom of religion?
Yeah, kind of First Amendment and this Freedom of Religion Restoration Act, are they persons for purposes of this act? And the court said yes. Number one, they are Alito wrote the opinion, the majority. He said, number one, yes, they are persons, no problem there. That's as controversial as that might be, no problem there. Going on from there, number two, as a person, they can exercise religious freedoms. You know, they're not just for profit. You know, I might have thought that, and a lot of people might have thought, and this was the argument, that wait a minute, a corporation is in the business of making profits. A for-profit corporation, that's its definition. So if it's in the business of making profits, if it's for-profit, what could its religious beliefs be other than, you know, maximizing profits? You know, it should be praying on the altar of profit maximization. You know, its only religion should be profit maximization, profits, right? But the court said, no, in a closely held corporation, by closely held, we mean a business that only has a few owners. You know, it's not publicly traded in the way that stock on the Fortune 500 stock is traded. In a closely held corporation, the person who owns, or people who own the corporation, can have religious beliefs and can exercise them. So we have no problem there. Then the question became, Andrew, okay, assuming we have a person here with Conestoga and with Hobby Lobby, do we have a substantial burden on their freedom of religion? Now, you know, the government was arguing there's no substantial burden here because they don't have to cover any of their employees. They'd have to pay, I think it was roughly a $25 million tax or penalty. I'm going to call it a tax because that's what Robertson wound up calling it, to make the individual mandate constitutional a little while back, right? He said it's not a fine, it's merely a tax. But they could not cover any employees, not cover any contraception, pay that 25 million tax, and get out of their moral dilemma that way. So the government was saying it's not a substantial burden because they have that way out. Alito didn't buy that. The majority didn't buy that. They said, no, it still is a substantial burden, even if they have that out, because they want to be able to provide fair and equal access for the rest of their employees, and they may care about that. And so we're just not going to say there's not a substantial burden here. So then we got to the third and final prong for the court's analysis, Andrew. We have a person, there has been a substantial burden on their freedom of religion, their exercise of religion. Then the question is there a compelling state interest for doing it, and is it nearly tailored? The court said, Alito said, no, there's a compelling interest here, no question about it. Women's reproductive health, the right to have reproductive protection, prophylactic protection against pregnancy is a compelling state interest. Unwanted pregnancies, unwanted abortions are reasons for the state that we can say are compelling, no question about that part at all. But the question is this narrowly tailored? Or could you have come up with another law that was more narrowly tailored that could provide access to women, for women to contraception, yet not burden the free exercise of religion rights of the corporations? And they said, yes, there are two options you had. Your number one state could have, since there are only four kinds of contraception we're really talking about here, Andrew, the employers weren't saying we have a problem with, for example, condoms. They weren't saying we have a problem with any kind of contraception that prevents conception. They said we have a problem with four kinds of contraception that happen after conception has occurred. IUDs, for example, and other kinds of diaphragms, other kinds of birth control that doesn't allow the fertilized egg to embed itself in the lining of the womb. Those kinds of contraception feel to us like abortions, said the corporations, and our religious principles forbid abortions, the taking of human life. And so we should not have to cover those particular four kinds of contraceptions. Well, Alito said, well, state, you could step in and subsidize women, pay for those four kinds of contraceptions to the extent that these employers don't. Number one, that's one way you could tailor it. Or another way is you could say you're going to treat closely held for-profit corporations just like you now treat nonprofit religious corporations. You say they're persons who are covered by the act, basically. You say they have an exemption, so you can treat these people like those people, and that doesn't open the floodgates because that doesn't cover, publicly traded corporations or anyone else. So at the end of the day, Alito said that you didn't come up with a narrowly tailored mandate for contraception coverage, narrowly tailored enough administration. So go back to the drawing board. So there we have, a thumbnail sketch of all the legal issues at play, Andrew.
What we're saying here is, as I said, the mirror image. We're saying, well, the corporation's religious freedoms perhaps trump the individual ones. If the corporation believes this, then everyone who works for that corporation needs to follow suit. Is that a correct reading, and is it dangerous?
Yeah, well, that is certainly one way you could read this. The court didn't go down that road, didn't adopt that characterization, Andrew, but it is one that was urged by many commentators that what you should think of here is, what you should think of this as is an attempt by employers to establish their religion, to impose their religious beliefs on employees who don't necessarily agree with them. So that is a move that you could make here. The counter argument, of course, is that, well, I'm not imposing my religious beliefs on you in the sense that I'm saying you can't have any of these contraception methods at all. I'm not standing in the way of you getting these if you want them, I'm just not going to subsidize them. I'm not going to support them. You can go out and find that support elsewhere from the government, for example. If the government cares this much about women's rights, the employers rather would say, the corporations, if they care that much about these set of issues, then they can directly subsidize these women's contraceptive rights through making an independent payment, covering the cost. And that way, we're out of the loop as corporations. So that would be essentially kind of the angle they would come at it in, Andrew.
Yeah, but just going further, because I've always believed that a ruling from a Supreme Court is important for the ruling itself, but even more so in the precedent and the road it takes us. Let's say we have a furniture company, and he's deeply religious, as you described this person, this corporation, and they say, according to our religious doctrine, homosexuality is a sin. It is horrible, it's nefarious, it's an abomination. And they say, well, because of that, and because, our corporate personhood finds this to be an abhorrent act, well, we will, A, not fund any treatments which disproportionately affect that population, and B, well, we have now the religious right to discriminate against hiring people who have that, because it is an offense to our religious freedoms.
Yeah, that's powerful, and when you frame it that way, it looks like there is an argument here that isn't going to prevail. That just seems to cut too much against the grain of our moral intuitions, Andrew, which is why Alito, in this opinion, went out of his way to say this opinion, this holding, only applies to these limited kinds of facts. When you have a closely held corporation,
which is about 90% of the corporations, though, aren't they?
A whole lot, and we're talking about contraception, and we're talking in the contraceptive realm, and we're talking about a concern over abortion. And abortion is a special kind of divisive issue, has been for a long time in America, going back to Roe Wade and before, right? That of all, there are lots of different kinds of moral issues that have been swirling in this country, but that abortion dilemma and conflict, boy, it's stuck with us, hasn't it? And he seems to be trying to cabin this holding, cabin this conclusion to say, don't worry about the parade of horribles that you're talking about, Andrew. Don't worry about the slippery slope. But with you, Andrew, I do worry about that slippery slope, because if you do set the precedent, at least in a general way, that an employer can disregard a legal requirement if that legal requirement conflicts with the employer's religious beliefs, then what if the employer doesn't want to cover blood transfusions, for example?
Or vaccines, sure.
Or vaccines, exactly. Or, or psychiatric care. There are some religious orientations that say, don't trust psychiatrists and psychologists. I don't want to cover that in my plan. It runs athwart my religious beliefs, right? And I should be able to avoid a legal requirement on the basis of my religious belief. So that makes it look like you do have to very carefully cabin this conclusion, Andrew, on the one hand.
Although, to some degree, it seems to me that it raised it artificially. And please tell me if I'm wrong on this one. Because as an employee or as an employer, and I've been both, when I'm choosing an insurance plan, I'm not actually sitting down, generally speaking, with my insurer and saying, okay, cover sprains, don't cover strains. Covering whooping cough, don't cover asthma. Cover cancer. We don't go through a checklist saying, I want this, I don't want this. You say, I want the good plan, I want the moderate plan, I want the most comprehensive plan. And then you're under whatever the insurance chooses to cover. And that generally happens for both the employer and the employee, right? There's not this picking and choosing.
Yeah, as a general matter, that's certainly true. But that is why the corporations would say abortion is different. It's a special kind of issue. It's one that has a long-standing tradition of controversy and divisiveness in the U.S. So, it should be kind of treated differently than some of those other kinds of concerns that you're raising, Andrew. And I think that they'd also kind of come back with this argument that, has some, kind of plausibility to it, that, you shouldn't make me participate in evil that I find morally and religiously repugnant. Because if you make me subsidize abortions, then you're making me complicit in the giving of provision of abortions. I am an aider and abetter. I become an accomplice in a practice in an institution that I find morally anathema. And so, that has a certain, even though I have a lot of problems with that argument in this particular context, Andrew, frankly, I'm not happy with this decision at all. I am saying there are these other dimensions to the case that problematize it and make it so that I can at least see how someone could reach this conclusion. I am Catholic. My mom was Catholic, and I'm torn. With the church, with the tradition I'm familiar with, you have a lot of concern about other people, about pooling risks, about taking care of one another, about looking out for one another. So, the Catholic Church, you would expect to be one of the last ones to be out there saying, don't help and protect people just because, rugged individualism tells you not to do that, like some on the right are saying. We don't like social insurance or risk pooling because it runs against the Ayn Rand rugged individualism that we should be pursuing. That's not the Catholic Church's approach. Catholic churches help, especially under the new Pope, but for a long time, we owe an obligation to the poor and needy among us. Let's help one another. But even they say you can help one another. We may support the idea of social health care and affordable health care in general, but don't make us complicit in a moral and religious evil that we as the church find anathema, and that is a tricky and difficult argument.